Hello, everyone. Welcome back to the School of Law. Today, we are looking at a crucial legal issue common especially in the construction industry, where workers are often loaned, shared, or seconded between companies. An employee with two masters, who is legally liable for his actions? Let's get into it. Question one: who is a seconded employee in the eyes of the law? A seconded employee is someone temporarily transferred by their original employer to work under another company. Legally, the first company is still the main employer, but the borrowing company usually controls the worker's daily activities. Question two: when an employee appears to have two masters, who is he actually answerable to? The answer is he is answerable to the employer who controls his work at that moment. That is the one giving him instructions, supervising, and directing how the job is done. This is known as a control test. Question 3: what does the rule that says when a servant has two masters, liability lies on the master for whom he was working at the time? The answer is it means that the only one employer will be held responsible if the worker commits a tort like negligence. The employer who had immediate control over the worker at the exact time of the wrongful act is responsible. Even if another employer is the general or permanent employer, they are not liable for that specific act. This principle was strongly emphasized in Massey Docks and Cogins and Griffiths, where the House of Lords held that the right to control is the decisive factor. Question 4: does the law ever make both employers liable? The answer is an absolute no. The law chooses one master, the one exercising control when the tort occurred. Only that employer bears vicarious liability. Question 5: what factors do courts consider to determine who was in control? The answer is courts examine who gave the instructions, who supervised the job, whose business was being carried out, who decided how, when, and where the work should be done. The employer who satisfies these conditions will be held legally responsible. Question 6: could you give a practical example of this rule in the construction industry? Certainly, yes. Here it goes. Imagine a crane operator who is employed by company Alpha but seconded to company Beta. On site, company Beta decides what loads he lifts, when he lifts the loads, where he moves the crane, how the job is done. If the operator negligently damages property while following company Beta's instructions, then company Beta alone is liable because they control him at the time of the tort. Company Alpha, even though the true employer, bears no liability for that particular act. Question 7: what is the key takeaway for employers and contractors as well as employees? A seconded employee may appear to have two bosses, but under the law, only one master matters. the employer who had control at the moment the tort was committed. That employer alone bears vicarious liability, not the one that initially employed him before the secondment. If you found this breakdown helpful, please leave a comment so we can share your experience in the next. Till we meet again, this is a day 3 of Edesis School of